Hi Empire Legal family. Alright, part 2 of our 2-part series on rental tenancy law reforms. So we kicked off last week with an introduction and spoke about the minimum housing standards. We're going to kick off with the remaining 3 topics for this stage 1 rollout. Okay, renting with pets, a huge topic, very emotional for a lot of people. Our furry friends are part of our family, but there's always a problem when you can't have them in a rental. So, what do you need to know? From 1st of October 2022, so last year, there were changes making it easier for renters to have a pet, including a renter can seek the property owner's permission to keep a pet, and property owners can only refuse a pet request on identified reasonable grounds, such as keeping the pet, breaching a bylaw, etc. Now, the property owner must respond to a request for a pet in writing within 14 days or consent is implied. And the final point, the property owner's consent may be subject to reasonable conditions such as the pet having to be kept outside, a rent increase, or a pet bond are not reasonable conditions. Okay, topic 3, ending tenancies fairly. So this rolled out in October last year, 2022. Changes under ending the tenancies fairly include removal of without grounds as a reason to end a tenancy. So, new grounds for property owners to end tenancies, including the end of a fixed term agreement, need to undertake significant repair or renovation, change of use or sale preparation for a rental property requires vacant possession. New grounds for renters to end tenancies, including the property is not in good repair or doesn't comply with minimum housing standard. Renters can continue to end an agreement without grounds, and both renters and property owners must provide appropriate notice for the ground or reason they are using to end the agreement. Now, property owners can seek an order from QCAT, which is the Queensland Civil and Administrative Tribunal, to terminate the tenancy for significant or serious breach of the lease by a tenant. Conversely, renters can apply to QCAT for an order to set a notice to leave aside if they believe it has been issued in retaliation for them enforcing their rights. Okay, now the final topic, domestic and family violence protection. This rolled out a little bit earlier in the piece, 20 October 2021, with the temporary regulatory measures that were introduced under the COVID-19 residential tenancies response for domestic and family violence becoming permanent. Now, renters experiencing domestic or family violence can leave immediately after giving 7 days notice and access any bond contribution that they made. They're not liable for any property damage caused by the domestic or family violence, not liable for costs relating to reletting the premises. Any remaining co-renters can be asked to top up the bond by the property owner or manager, can change the locks to the property without requiring the owner's consent to ensure their safety, and must provide documentation to support their claim. Property owners, managers, and the employees must not disclose this information except where permitted and may be subject to penalties where they do so. So, a huge update to make sure that anyone subjected to domestic or family violence, which does still exist, guys, it's still a big problem in Queensland, are protected. Now, obviously, I've just given you a very broad overview of these topics, and this is only stage 1. If you want to know more about it or anything I've just spoken about in stage 1, the RTA website, rta.qld.gov.au, that's the authority for all of this stuff. They are the body for rental laws in Queensland. I highly recommend, if you want to know more, you check out their website or give them a call. Hopefully this has added value and given you guys a little bit more about, I guess, where we've come from and where we're going. Any property questions, Empire Legal, reach out to us. We'd love to help or point you in the right direction. Thanks, guys.